We're going to start with number 171, People versus Israel. Counsel, you want any rebuttal time?
3 minutes, Your Honor.
3 minutes. Go ahead. You're on.
Thank you. Good afternoon, Your Honors. Jan Hoth for Appellant Daniel Israel. As this Court made clear in Santorelli and its progeny, evidence of a defendant's bad acts is only admissible to rebut a state-of-mind defense.
Counsel, let's talk about these particular three instances. Why aren't they appropriate under the circumstances that come in, in terms of this issue that's been raised about EED? And why is it not appropriate?
Well, I think we have to look at each incident
separately.
Yes,
let's take them one at a time.
And there's problems with each incident.
Yeah, let's hear it.
Okay, so if we discuss the incident where the prosecutor asserted that Mr. Israel punched and choked a woman in response to taunts aimed at his mother. But that's the prosecutor. We don't know if that's what happened. They didn't provide a sufficient and detailed foundation. If their aim was to show that Mr. Israel reacted violently without provocation, they need to bring in the girl or a witness to the actual event, not just the prosecutor's assertion of what happened at that event.
What about Mr. Lucas's testimony, Ms. Huck? Was that Lucas was Mr. Israel's witness, right? His former friend or good friend, and he testified to that. Was there a problem in having him testify to that?
Well, he didn't testify to it. The district attorney was allowed to ask him if he had heard of that incident. And his response was that he had heard something about it, but his understanding was that Mr. Israel pushed the girl. That's all he could say. The defense expert was asked if his opinion would change if he heard of that incident, and he said no. There was no direct evidence, no witness was brought in to testify to the incident itself.
So you're saying that if a witness had come in and said exactly what it was that the prosecutor alluded to, that would be okay?
No, I think it's a two-step evaluation that you have to go through. First, the district attorney has to establish the foundation or the context, so to speak, that
but he was described as being a peaceful, laid-back, nonviolent person. So does it really matter, at least as to that incident, exactly what the context was?
Well, I think it does, especially with that incident. If you look at it, he was a juvenile. He was only 16 years old. And 16-year-old boys may react in ways that other people would find inappropriate.
But then how could the people rebut this testimony?
Well, they had their own psychiatrist who was testifying. This was a case about whether Mr. Israel was suffering from post-traumatic stress disorder at the time.
But why couldn't this come in just as a way of evaluating the psychiatric testimony?
Well, I'm not sure how it helps evaluate the psychiatric testimony.
Well, what was the psychiatrist's testimony about the incident?
Well, the psychiatrist, when asked if his opinion would change, having heard of that particular incident, said no, it would not, that maybe it wasn't an appropriate reaction, but it didn't show a pattern, it didn't show pervasive conduct.
So why isn't this relevant in terms of this issue that's been raised? You asked a friend about it, right, what's the harm in letting it in?
Well,
how was it prejudice your client?
Well, the harm, of course, is that here in particular, and we haven't even gotten to the other two incidences, the district attorney was also allowed to bring in two witnesses to testify to three separate incidences in which Mr. Israel may or may not have been provoked. It's clear.
What about the 05 incident?
The 05 is with the chicken restaurant.
Yes. What about that?
Well,
did he preserve that?
Yes, Your Honor.
Preserve that.
Counsel complained repeatedly from the get-go that they needed to have the witness testify to the whole event.
Well, on the 05 incident, didn't he waive any objection to that by cross-examining Police Officer Marino?
No, Your Honor. The district
Why not?
attorney misled the court as to what her witness was going to testify to, whether inadvertently or not. She kept insisting that she had a witness who had seen the whole thing. The court was very concerned that unless the witness had seen the whole thing and could testify, it had
Yeah,
the
but then the court gave counsel a choice. Counsel made a choice. Did he
Yes.
make the choice over objection? Did
He
he say,
made-
I object, but if these are my only choices, then I choose?
No, what specifically happened was when the officer said he wasn't there at the beginning of the incident, counsel objected, they
Yes,
had the
yes.
sidebar,
Yes.
and again objected that the witness had not seen the entire incident, and the court gave him a choice. Making the best of a bad situation is not waiving an objection.
What should
They-
the court have done? Should the court have declared a mistrial because that testimony came in? What was the other choice? That's
Well, the choice was to strike the testimony or to allow counsel to cross-examine the witness.
What's the harm in light of the fact that the police officer indicated that, the server could have initiated the fight? There was no, right? What's the harm?
Well, the harm...
Got to cross, and on cross, the police officer said, maybe the server did initiate the fight.
Because what the prosecution was doing was painting a picture of Mr. Israel as someone who was subject to violent outbursts and therefore was not suffering.
Again, as relevant to the psychiatric testimony, they wanted to show that he's a hothead or, as you say, gets excited easily.
But if they're trying to show that he is subject to violent outbursts without provocation, then they need to bring in the evidence to show that it was in fact without provocation.
Is it really without provocation, or it's with respect to the type of trigger that provokes his violence?
Well,
I thought it was more inappropriate response, inappropriate violent reaction. It's a difficult evidentiary problem because how broad of a time frame do you have to look at to examine whether or not it's probative or prejudicial? I can see the argument. The problem here is that you have three incidents. The first is a 2002, which, only speaking for myself, seems to be admissible. 2005, you seem to have waived on 2005. In 2010, the Rikers Island incident may be more problematical. The question there is it harmless error or not? I can't say that I know the answer to that, but those are the kind of things I think we need to look at. There seems to be a continuum, but the three different incidents in a different time frame.
Yes, Your Honor, but the problem is that all three came in. Whether the chicken restaurant would not have come in had the prosecutor made sure she understood the nature of the officer's testimony before she put him on the
But
stand.
then the judge gave the choice. I'll strike the testimony. Counsel didn't make that choice.
No, counsel was given a choice to make the best of a bad situation. By choosing to cross-examine the witness, that's not suddenly a windfall to him. The witness should never have been on the stand. The court would never have allowed the witness on the stand.
Okay,
Thank you.
You'll have your rebuttal. Thank you. Counsel.
May it please the Court, my name is Deborah Morse, and I represent the people on this appeal.
Counsel, why didn't these three incidents prejudice the defendant? In that do we know the whole story of how they began, what the provocation was? Why is this more probative than prejudicial? And if it is, what's the relevance? What are we looking towards?
Okay, so Your Honor's question has so many different parts.
Go, answer them.
Of course, any evidence that comes in from the people against defendant is going to be prejudicial. The question
Yes,
is
it's
it
the weighing. Go ahead.
undue prejudice? But in this case, the issue was relevance, which is different from...
What's it relevant to?
It is relevant to, and that it is relevant to the fact that this was a very specific defense in this case, not just EED defense as other cases have had. This was a case where defendant urged, the way you know that I acted out of EED is because my very nature is nonviolent, and that's critical. And the defense expert hinged the EED defense on the notion that the defendant had a nonviolent nature. He actually used the words that
Well, how can that be if his own witness says he changed? He's not the same.
Well, his own witness...
Lucas, we're talking about Lucas.
I know what you mean. Yes, Your Honor. He said he changed, But Lucas, I'll get back to the expert because that was actually said a number of very strong things. But even Lucas supported the idea because Lucas said, even after the trauma, defendant did not go out, and I had written down his exact words, he didn't go, he was still, he didn't go out and commit violent acts. He just wasn't as calm as he was before. And that's on 675, 676.
So you're saying because of this, because of the way he presented his defense, any acts of violence, no matter how they occurred or why they occurred or what the circumstances were, would be relevant and admissible?
No, Your Honor, not any acts, not at all.
So then
But
what acts would be, what acts wouldn't be?
the acts that would be admissible and the acts that were admissible, were admitted here, because the judge actually kept out many acts, the ones the judge admitted were those that were tailored specifically that had, and of course the standard for relevance is quite
Counsel,
low.
but what about the 2005 incident?
Yes.
Where we don't know how this thing all started. Why would you let that in?
Well, first of all, I would just say, Your Honor, it was a mistake. When this happened below, there was no suggestion whatsoever by anybody, defense counsel, the court, that this was anything. Now it's called a duping, but this was just a mistake. On the theory that the prosecutor thought that the police officer had witnessed the entire event and even heard what was said earlier.
So
But-
is your argument that it's a mistake, but it doesn't matter?
No, I would say, honestly, Your Honor, I would say that this particular trial judge was so scrupulous and so meticulous, I think an argument can be made that even with the non-hearsay information here, the evidence could have been admitted, because what you had, even just based on this officer's firsthand testimony, was defendant leaning across the counter, grabbing a counter guard. I'm
But
sorry.
the judge decided it shouldn't have been admitted.
Exactly.
And then gave some alternatives.
Exactly.
And then counsel chose one.
Yes.
As opposed to the other. Are you saying that the defense counsel should have chosen to have the testimony stricken?
No, Your Honor,
Curative instruction, or what is
No,
your
Your-
position?
I think what Your Honor's said was actually quite accurate, is that defense counsel was given the choice of what to do because the trial court was concerned about having admitted it under these circumstances. The judge offered to strike it completely, give an instruction to ignore it. Defense counsel opted for cross-examination, and defense counsel did not ever ask for a mistrial. Your Honor asked what should have happened. That's the correct question, what should have happened. Defense counsel did not ask for a mistrial and didn't say in any fashion, oh, well, I can't do anything under these circumstances, you can't cure it. There was nothing to that effect. In this case, actually what happened is defendant was able to present what amounted to a false exculpatory version of the events, because we have all the information that we have in that case. And by the
Are
way,
you saying that is one of your arguments that they opened the door to all of this?
Absolutely, Your
I mean,
Honor.
would you not have put it in if they didn't open the door?
I would say that's accurate, Your Honor.
Well, you wouldn't
That-
have been able to. Santorelli you wouldn't have even been able to, this evidence only comes in response, in rebuttal.
Yes, and Your Honor, and I believe that the reason that it comes in response is because the language, and it's very specific about relevance, is that it must be, the information must be tailored. It must be specifically tailored so it has Your Honors know better than I do, so it has a natural tendency to.
Well, how does somebody pushing someone up against a wall or punching a fast food worker in the face have a natural tendency to show that someone is so stressed that they would shoot into a crowd?
It doesn't, Your Honor, it doesn't show that he would be so stressed to shoot into a crowd. In this case, his defense went much further than that. His defense said, the defense came from his expert. His expert said, in essence, but I can read you the exact language, the expert said, he committed EED because it's against his very nature. He said, he said, defendant used violence only defensively. These are quotes from the record. Fought only when he couldn't avoid it. He never took out his anger for no good reason. The expert, the psychiatric expert, went so far as to label defendant serene. He said defendant was normal.
The expert knew about these incidences
Yes.
and still came to this conclusion.
Yes, Your Honor. In
But
fact,
isn't that the point, that he only used it defensively? He only used it, when he was, but if we don't know the circumstances, then how do we know that these situations rebutted that proof?
we do know in these circumstances, if I can just take them one by one. The first one was a little girl who insulted defendant's mother. And what defendant did was he punched her, choked her, and threw her against the wall. He was adjudicated a JD based on that. I mean, that didn't come in, juvenile delinquent, that didn't come in at trial. But I'm saying, in this case, we know what happened. That information went in front of the jurors because it conflicted with his, I'll call it Gandhi-esque portrayal of himself that,
Okay, well, what about the KFC incident?
same thing. In that case,
We don't, but nobody knew what happened before the moment that the police officer walked in and saw him doing what he did, but we don't have any idea what happened before that.
I guess this could be a very fine, there's a distinction I'm making just for the purpose of answering that question. We do know, actually, the jury wasn't allowed to hear because it was hearsay. We do know that, in fact, there was no punching, there was no threat of violence, there was no weapon, there was nothing. Defense counsel was allowed to bring out that possibility because of the fact that we didn't have non-hearsay evidence.
But that's the
you're
proof
right.
that we're dealing with.
Absolutely, Your Honor. So in this case, what I would submit is, that's why I say there is a reasonable minds could differ, perhaps, that when you have a situation where you have a defendant, a guy reaching across a counter to grab a guy and punching him in the face, it doesn't naturally lend itself to the idea that perhaps...
But isn't that the whole problem
Yes.
with the bad acts? And that's why the cases, Santorelli and the rest of these, are written as they are. That, as you say, they're tailored to show this natural tendency
Yes.
to the violence.
Yes.
Because of that very fear that otherwise you assume that every violent act is indeed showing this proclivity to be violent, and that's what happened in this case,
But
right?
what-
So that is why what provokes him, because that is his defense, that there is a trigger. What provokes him is what's critical for each of those incidences.
But what I would say, Your Honor, is there's a very big distinction between this, a number of distinct, but in terms of what you just said about Santorelli and what was really at issue. The evidence here was not admitted to show that defendant, or could not have reasonably been read. The issue was not he had a violent propensity. This was where defendant portrayed himself as someone who, by nature, wouldn't do this, but
Yeah,
for
but the
trigger.
overall
So-
effect is that he had a violent propensity. That's why you're offering it.
No, Your Honor, absolutely not, because in this case, he had an expert. He put forward a specific defense. It wasn't like in Santorelli.
Was that his main defense? I know you've quoted
Yes.
from the expert's testimony, counsel, but I thought the expert was saying he suffered from PTSD, and that on the date of the incident, the shooting, he was reliving the PTSD, what happened to him at the stabbing. So, in 2005. So what you say seems to me that the expert testified to is somewhat peripheral to the main defense, which was PTSD, and he was reliving this.
I know exactly. In this case, it's an unusual case, and Your Honor, see the record. This expert did not base his conclusions about PTSD and about whether the defendant was suffering from it on any basis like the people's expert based it on diagnostic tests and all sorts of scientific things. This defendant, this expert, went out of his way and actually hinged his EED defense almost entirely on the notion that it was a non-scientific notion, frankly, in some level. That was what our expert said, is that he wouldn't have done it because it's against his nature. And if you look throughout the testimony, he said things, that he wants to be nice. Defendant wants to be nice. He wants to help others. He wants to be a good person.
Okay, counsel.
I'm sorry.
Thanks, counsel.
Okay.
Counsel, what about that? Your adversary says that the whole defense is based on his nature, that's what's about, that he has this nonviolent personality. Is that the heart of what your medical evidence showed?
The heart of the defense was that appellant, as a result of his own stabbing, was suffering from post-traumatic stress disorder. This is something that even the prosecution's expert did not dispute, agreed that the stabbing caused post-traumatic stress disorder. The question was whether he was still suffering from it at the time of the shooting, and whether the post-traumatic stress disorder, the trigger of seeing his friend.
Don't the first two incidents go towards answering that question as to, whether post the original issue that caused him the trauma, that those incidents show that he's
The point is that they might show that had the people established the context and the foundation. My adversary said that the first incident was punching, choking, pushing. It was the trial assistant who called it punching and choking. The defense witness said, no, I think he pushed her, and now my adversary calls it punching, choking, and pushing. So we don't know what happened. We have a defense witness who said, yeah, I heard something about it, and I think he pushed her.
Therefore prejudicial to your side?
Totally prejudicial, and it doesn't go to the question of whether seeing his friend being attacked in a situation somewhat similar to when he was himself attacked and stabbed triggered his post-traumatic stress disorder. EED.
So that means the only kinds of incidences they would have brought in is a stabbing or a shooting or something like this that looks like that moment?
No.
That the defendant claims triggered this response?
No, Your Honor, that's not what I've been saying at all. What I've been saying is that this evidence might have been relevant had the people had the evidence to show that Mr. Israel was acting without any provocation whatsoever, that he did in fact have a violent nature. Aside from the fact that he was a juvenile at the first time, if that's what they had been able to bring witnesses in to show, then it may have been relevant. I'm not saying they had to bring in an actual shooting, although there is some question as to whether pushing someone is a precursor to walking down the street and wildly shooting at a crowd, including 2 uniformed officers who are repeatedly telling you to drop your gun.
Not commensurate to the conduct.
Excuse me?
Not commensurate to the conduct. Is that what you're saying?
It might not be, but I'm not saying that it wouldn't totally be relevant. What I'm saying is that without the adequate and foundation, the context that shows that him pushing or choking or whatever it is he did have a natural tendency to disprove his defense. You can't just bring in evidence, you can't bring in hearsay, and you certainly shouldn't be relying on the trial assistant's representation.
Okay, counsel. Thank you both. Appreciate it.